The Court of Appeal constituted Justices of Appeal Fraser and Philippides and Justice Duncan McMeekin. Each member of the court expressed the view that the principle affirmed in Robert Bax about the admission, the unqualified admission of, for example, hearsay evidence in statements and documents, did not apply generally in relation to expert reports. Justice of Appeal Philippides, in agreeing with both Justice McMeekin and Justice of Appeal Fraser, made the concise comment that the Robert Bax principle, quote, was not expressed to extend to the position of original documents in the form of an expert report which concerned a distinct category of case with well-established principle. In the absence of any evidence that the training in fact provided did not provide the basic or fundamental training, the plaintiff's claim was dismissed on appeal also. The court observed that in the absence of that evidence, amongst many other things, no evidential onus had passed to the defendant warranting it to call any evidence on that point or to challenge the plaintiff in cross-examination. Secondly, the burden of proof of the plaintiff had not been discharged. Thirdly, it was in fact the plaintiff who might have the Jones and Dunkel type inference drawn against the plaintiff for failing to address the issue. There are also several reasons why the statement in the ergonomist's report could not be treated or should not be treated as proof of the fact alleged. And in this respect, Their Honours exposed what I respectfully suggest to you are some pretty important reasons going to the very heart of the jurisprudential difference between an expert report as an exception to the general prohibition of opinion evidence and the treatment of other evidence as original evidence. Firstly, at the time of the tender, there was no indication made by counsel tendering that the statement was in fact intended to be relied upon as proof of the fact. Now, the reason that's important is, as I mentioned earlier in this presentation, an expert's report can be assumed by the person receiving it to be a report which is based on facts which will be otherwise proved, and therefore it would be grabbing the wrong end of the stick entirely for the opposing counsel to think that the report proved itself in relation to those facts. That's not the way it works. Secondly, the defendant, the respondent in the appeal, was entitled to assume, consequently, that the relevant admissible evidence would be presented to support the expert report otherwise in the course of the trial. However, that turned out not to be the case. And I might add, that was a point taken for the first time on the appeal, and the court noted in passing that it was not there for a point which they would allow to be raised for the first time on appeal because counsel below had not had the opportunity to deal with it. Thirdly, hearsay statements in an expert report stand in a, quote, special and different category to hearsay statements in other documents. Their Honour said that to extend the Robert Bax principle to expert reports would not be consistent with extensive High Court authority and long-standing principle. Can I also add, respectfully, it's illogical because without the other facts otherwise being proved, the report would end up proving itself, which runs entirely contrary to the basis upon which an expert's opinion is to be expressed. Fourthly, to implement a requirement that the counsel who is opposing the expert report in court should formally object to such material on each and every occasion a report was led in evidence would create unnecessary work and complication at a trial and absorb unnecessary time and effort at a trial. Their Honours also commented that it would potentially reward unmeritorious cases in the event that objection wasn't taken. Interestingly, Their Honours also noted a, quote, further concerning feature if the Robert Bax principle was extended to expert reports, and that was that the assumption underlying the tender was that counsel, who's tendering it, was in a position to prove the facts upon which the expert relied, or at least those facts which were essential to the opinion. If it were otherwise, the court noted, counsel would be deliberately putting before the court evidence that was inadmissible and which counsel knew could never become admissible. Tender in such circumstances would be tantamount to misleading the court. Now, for those of us who are advocates, that's a scary thought. That's something we never want to do. In such a situation, Their Honours said, it was impossible to see any waiver of right to limit the use to which the evidence may be put. So what can be taken from Beaven? Well, a few things. First of all, Beaven demonstrates that if you are a party intending to rely upon the expert opinion, the essential facts upon which the expert opinion relies must be independently and admissibly established, unless you've reached agreement with your opponent. That requires you to carefully consider the report, look at the facts upon which your expert is relying upon, and map out and ensure that you have an admissible basis for each and every fact, or at least the essential components of the facts upon which your expert replies. Often that may require you to confer with your expert and nut out exactly what it is that the expert has relied upon. Quite often you'll find that there is some assumption made by the expert which isn't apparent on the face of the expert report. Everyone before a trial will of course confer with their experts, but take the time to actually tease out of the expert precisely what it is that the expert's relying upon in each aspect of that expert's opinion. You might be surprised to learn that there is, in fact, another event, fact or detail which the expert assumes everyone agrees upon, that the expert's relying upon. Now, if you have a clever opponent, and you should assume that you will, your opponent may have realised that and may be lying in wait to object to the report, or at the end of the trial indicate that the expert's report is of no value because you haven't proved a particular fact or facts. Secondly, practitioners should be alert to an expert relying upon evidence which is inadmissible and which could not be independently proved, or it may be in a form or is of a nature which would be ultimately inadmissible anyway. In the conference you have with an expert, you might learn, for example, that the expert is relying upon a particular fact which the expert has learnt from another expert. That's often the case. Quite often also an expert might be relying upon facts which might be notorious in that area of expertise, which also, however, might need to be proved. Thirdly, evidence not contained in experts' reports must be considered carefully in relation to the basis of its admission. And this is the obverse of what occurred in Beaven, and in fact what occurred in Robert Bax. We all like to have bundles of documents, and indeed there is shortly going to be a practice direction in the Supreme Court anyway, which requires the parties actively to agree on bundles and lists of documents, because many documents are and should be uncontroversial. But beware, have a look at what's in the bundle and think about the basis upon which it's being admitted. You might think correctly that a particular document is being admitted because it's relevant to point A, but it might also be relevant to point B, and point B might be highly contentious from your point of view. If it is to go into the agreed bundle, it ought to be made clear that it goes in on a qualified basis, that is, it's only admitted for point A and that point B remains contentious. And if you can't agree, then you should object and you should remove it from the bundle, and if need be, however regrettable that may be, you raise your objections and deal with it at the commencement of the trial or at the appropriate moment of the trial when it's sought to be tendered, presumably by some otherwise admissible means by your opponent.